few comments tonight regarding this momentous decision that was made this morning by the United States Supreme Court in a divided decision. The opinion was 5-4. Essentially, this court has killed the limits on corporate influence into our politics. Let me start out by reading a few excerpts from the Wall Street Journal, the Wall Street Journal is a financial publication, as you know. They're quite pleased with that decision. A divided Supreme Court struck down 2 decades-old limits on corporate political expenditures, potentially reshaping the 2010 elections by permitting businesses, and in parentheses, unions, to spend freely on commercials for or against candidates. They go on to say, President Obama attacked the ruling and said it gave a green light to a new stampede of special interests money in our politics, particularly big oil, Wall Street banks, health insurance companies, and the other powerful interests that drown out the voices of everyday Americans. He pledged to work with lawmakers to craft a forceful response. Now, this is coming from President Obama, whose own campaign was financed by the very entities that he is now verbally attacking, but is not really doing anything about them. Of course, the Wall Street Journal didn't write that little comment. Senate Minority Leader Mitch McConnell, and this again is the Wall Street Journal, a Kentucky Republican who has long fought campaign finance regulations, hailed the court for its monumental decision towards restoring the First Amendment rights of corporations. And the Wall Street unit puts this in parentheses. I mean, the Wall Street Journal puts this in parentheses, right? Corporations and unions, you know, as if unions have any huge influence in this country anymore. By ruling that the Constitution protects their right to express themselves about political candidates and issues up until Election Day. Some company executives and unions, this is the Wall Street Journal talking, said that they were ready to jump more directly into this year's congressional races and campaigns under the new rules. But big companies may remain a little bit cautious about doing so for public relation reasons. I'll go on a little bit more here because it's falls under the rubric of fair use. Justice Anthony Kennedy, writing for the majority of this decision in his 57-page opinion, said the effort to divide corporate political spending into legal and illegal forms chilled free political speech. When government seeks to use its full power, including the criminal law, to command where a person may get his or her information, or what distrusted source he or she may not hear, is the control. It uses censorship to control thought. In other words, Justice Kennedy expresses the opinion that ads amount to information. Campaign ads actually amount to truthful information. Justice Kennedy wrote that, taken to its extreme, these restrictions on corporate spending could silence media organizations or even allow banning such political-themed movies as Mr. Smith Goes to Washington. I mean, this is basically laughable on its face, since our entire media is corporate-owned to start with. Our mass media, that is. He rejected the view that government had an interest in preventing corporations or unions from distorting the political debate by funding ads. No, of course not. You know, they wouldn't do any such thing. They wouldn't want to distort things now. To the contrary, corporations may possess valuable expertise, leaving them the best equipped to point out errors of fallacies in speech of all sorts. In dissent, Justice John Paul Stevens, and remember, John Paul Stevens was actually appointed by a Republican president. Nominated by a Republican president, I should say. Part of the majority in these two previous opinions that were overruled called the majority opinion a rejection of common sense of the American people, who have fought against the distinctive corrupting potential of corporate electioneering since the days of Theodore Roosevelt. To underscore his distress, Justice Stevens took the unusual step of reading much of his 90-page dissent from the bench. So far, I have not been able to find this 90-page dissent online. I tried it about an hour ago, and the website of the United States Supreme Court is so busy, I think their servers have crashed by now. And I might add that Justices Ruth Bader Ginsburg, Stephen Breyer, and Sonia Sotomayor joined that dissent. And, of course, so will I. Now, I think many don't understand how huge this is. So let me put it this way. The American experiment has failed. Government of, by, and for the people is basically done. You will now choose your leaders from amongst a pool vetted and approved by major corporations who will act on their behalf. Welcome to the Incorporated States of America. I read a comment on a website which said, "How long will it be till government begins to display the ads of their sponsors on their jackets, rolling digital ads circulating the rotunda?" I'll try to research this some more, and I'll try to find the dissenting opinion as well once it is posted online. This is a terrible, terrible decision.